Welcome to the next installment of the Weber Gallagher webinar series. I'm Robert Hanneman, and along with partner Jennifer Laver, we're going to discuss Section 40 lien rights today. At the end of our presentation, we're going to have a brief comment regarding subrogation rights by partner Larry Bennett of our General Liability Department. So let's get started. Jen?
Good morning. What we're going to talk about today is we're going to explore when Section 40 rights apply, how to calculate consideration for waiving or compromising them, and we're also going to determine whether or not you should actually file a third-party suit on your own, specifically the carrier.
What are Section 40 lien rights? Pursuant to NJSA 34:15-40, you have the right to recover if the injured worker recovers in a third-party suit. It's considered double recovery if petitioner gets money from a third-party suit as well as recovery in a workers' compensation case. As you see from the PowerPoint, the carrier can recover up to 2/3 of whatever it paid, depending on the recovery by the injured worker, less cost of litigation exception, which the court has determined is $750 now.
Now, we know that $750 isn't really what the costs are, but the carriers get the benefit of the fact that it's only reduced by $750. So just keep that in mind.
It should be interesting that up until 3 or 4 years ago, it was only $250. So they've added the cost a little bit, but really the costs are insignificant. Mm-hmm. If injured worker recovers more than your lien, then the lien rights go out into the future if the petitioner tries to reopen their case. As you know, New Jersey has the right to reopen workers' compensation cases in certain situations. If the injured worker recovers less than the lien's rights are exhausted and no further benefits are due to the carrier. If the injured employee does not bring suit, the employer and the insurance carrier can bring the suit themselves to recover the money they paid under the workers' compensation benefits, but they step into the shoes of the injured worker. They have to notify the injured employee that they plan on bringing suit. They can do 1 year from the date of loss if it's not pursued by the injured worker.
And we're going to talk about whether or not you should consider pursuing that later on. There's a lot of changes that have been going on as to whether or not you should be handling a third-party claim. So we're going to discuss that a little bit later on.
One of the things you should consider that if you bring the suit separately as the carrier, you can recover 100% of your lien rights. Mm-hmm. The reason why we collect 2/3 is because the court deducts 1/3 for the counsel fees that are obtained by the third-party petitioner's attorney. You have to give notice to the employer saying that at least 1 year has passed since the date of loss before the carrier can pursue the suit on their own.
Mm-hmm. We're now going to talk about when Section 40 lien rights apply. Whenever there's a third-party claim, they would apply. However, there's specific instances where they may not apply or where you should consider whether or not it's something you should be accepting or going after, even if you're told that they don't apply. So in the Weir case, it's Weir versus Market Transition Facility. In this case, this is a injured employee who was involved in a motor vehicle accident, and he received benefits. There was a significant injury, subsequent infection, and then surgeries, multiple surgeries. As part of his third-party claim, he not only filed his claim, but his wife also filed her per quad claim. And the claim ultimately resolved for $300,000. The issue was the $300,000 wasn't apportioned. So because it wasn't apportioned between all the different claims, the Section 40 lien rights, the carrier argued that they applied to the entire $300,000. That would include the wife's per quad claim. And so in this instance, the court determined that the per quad portion of the claim was not part of the Section 40 lien rights. Specifically with regard to this issue, the damages are personal to the spouse. So while there is a derivative claim from the original accident, this is separate. So it's something that you need to really consider. The other issue is that the petitioner tried to actually get the money back. What ended up happening was the appellate court had indicated that the wife's per quad claim is a separate and distinct claim, and therefore she could recover her money, and that would not be part of the Section 40 lien. However, they had a little bit of an issue as to how the trial court separated and determined how much was the wife's claim out of 300,000 compared to how much was the employee's recovery. With regard to that aspect, the employee in the current claim, when the carrier was trying to recover the entire $300,000, he tried to say that his injuries weren't that much, but that his wife's, the impact of his wife's per quad claim was significant, and there was a little bit of an issue and dispute with regard to that. So the appellate court kicked it back and remanded back to the trial level the separation of how to apportion that. So they wanted a little bit further investigation. But that type of case lets you know that while you can recover for the third party, it would not apply to the wife's per quad claim. We also have some other examples of types of claims that you should consider recovering. If there's medical malpractice as part of a workers' comp claim, so you could have an injury during physical therapy where the physical therapist didn't listen to the treating doctor, and as a result there was a serious injury. An example, let's say they tore their shoulder and they had arthroscopic repair, and then they ended up in PT injuring themselves so severely that they needed an additional surgery. You would be able to recover on the third party claim your Section 40 lien rights. They wouldn't go back to the original injury because that's not when the third party claim actually resulted, but they would come from the date of that injury with the physical therapist. So you would have your Section 40 lien rights from that date ongoing. So it's something to keep in mind, those types of injuries and those types of situations. You also would have those if, with regard to a workers' comp claim, let's say that there was a legal malpractice claim, because there should have also been a third-party claim with regard to, let's say, a motor vehicle accident. And they never filed the claim, and there was a blown statute of limitation. And as a result of the attorney not notifying the client of that potential or filing a claim of protecting their interests, there was a malpractice claim against the attorney. You would be able to recover your Section 40 lien rights from that legal malpractice claim because it still stems from the original injury. So that's something to consider.
Now what we're going to talk about is how do you actually calculate the workers' compensation Section 40 lien rights if the workers' compensation case settles before the third-party case. In New Jersey, when you resolve the case pursuant to the order approving settlement, you'd reserve your Section 40 lien rights with regards to the future benefits paid. Usually at the time of the order, you would have resolved under your Section 40 lien rights the issues of medical and temporary disability benefits, because at the time of the OAS, you would know that. If the third-party case is not settled, then you reserve all of those rights going out into the future. Once the third-party case settles, then you receive a lump sum less than 1/3, assuming that was the attorney's fee. If it does not exhaust your lien, the lien would then go out into the future, and you would wind up paying future benefits at the rate of 1/3 until your entire lien is exhausted. There was a case decision, it's called the Owens decision, that allows for acceleration of the payments for the workers' compensation case. What you would do is you would subtract your credits, and then the remaining balance would be paid to the petitioner in a lump sum, regardless of how many weeks are still owed to the petitioner going out into the future.
So keep in mind, if you've already settled it and the third-party claim then settles, feel free to contact us if you're not exactly sure what you should be doing. But as Rob said, you would accelerate the benefits. So whatever's remaining, you would obviously get your lien rights from that point, and you would collect from that point. But the remainder you would then pay at the 1/3 rate, and you would pay it and accelerate it under Owen. So just keep that in mind.
One of the things you have to consider is, because we pay benefits out into the future, this does not change the statute of limitations just because you paid the benefits in a lump sum. Whatever the end date would have been for the last date of payment, they would still have 2 years from that date to reopen their case seeking additional benefits. The positive aspect of paying the lump sum is, one, you're done making the payments, and if petitioner does reopen with additional Section 40 lien rights, the carrier only pays any future medical or temporary disability benefits at that point at the rate of 1/3. The petitioner is responsible for the remainder of that dollar figure.
So a lot of times it's sort of an enticement for them not to come back and try and get additional treatment because they don't want to pay their 2/3.
Right.
So having that reserve in the future a lot of times prevents us reopen our claims.
And we've seen private insurance carriers reject petitioners' attempt to have those additional bills paid under their private insurance, claiming that they don't have any further workers' compensation benefits. They actually do. They're just not entitled to them because of the credits.
Right.
How do you calculate it? What do you do when the counsel fees in a third-party case are less than 1/3? We give you a couple examples.
With regard to the examples of the calculation, so in this example, you have a $15,000 recovery. There's a $120,000 lien. So in this situation, obviously, the recovery is much less than what the lien is to date. So what you're going to do is you're going to take that, the 2/3 of the recovery, which in this instance is $10,000, less the $750, and your potential recovery is $9,250. So that's in the instance of when the recovery is less than what the lien is. Assuming the recovery is more, so in this second example, we have a $200,000 recovery. 2/3 of the $200,000 less $750 is $132,583.33. So that's your potential recovery. In this instance, let's say you have a med and temp balance where there's an $80,000 lien to date. So what you would do is, in this instance, the workers' comp case hasn't settled, so you just paid medical and indemnity. And with regard to that, you would recover $52,583.33 now. You would still have $80,000 for that lien into the future. So you would want to keep those lien rights and acknowledge that. In this instance, let's say then the workers' comp claim settles, you're paying 15% of partial total, which is 9 weeks at $239 for $21,510. For that award, when it settles, you're only going to be paying 1/3 of that. So the 1/3 would be $7,170. You would then still, as normal, subtract the petitioner's portion of fees and costs, and then the petitioner would get the net balance of that. Keeping in mind, though, your lien rights that you've now used are $14,340. That's the 2/3 of the award. And under Owens, again, you would pay that in a lump sum, so you would pay the $7,170 less the portion of fees and costs. Doesn't matter if the weeks are fully accrued, you would accelerate the benefits. And then taking the $80,000 that was remaining less the $14,340, you would then have $65,660 in future lien rights. So again, if there's a reopener, you want to pay those at 1/3. So for all the medical, you're going to pay that at 1/3. And again, if there's temporary disability benefits, you're paying that at 1/3 until the lien is extinguished. One of the other things that you want to consider is whether or not you should be waiving them. Rob and I constantly get calls, whether it's before or after the claim has settled, asking us, I was contacted by the third-party attorney, and they want us to waive our lien rights, or they want us to compromise them. Whenever you get those calls, a lot of times we suggest you contacting us because it depends on the circumstances as to what you should be doing. Many times we recommend consideration for compromising, especially if it's an effort to get the claim to resolve without you having to take on the cost of litigation. However, the way in which you do it, it's really important. A lot of times they'll ask you to do a third after the costs have already been deducted. We don't recommend that you do that unless there's a specific reason, because then you're getting less than what you really should be getting. On top of that, we recommend that even if you agree to compromise, make it clear that you're still reserving your future lien rights. So in the instance of, let's say, the workers' comp claim, the permanency hasn't settled, you would be agreeing to pay the third, to compromise the third for the med and temp portion, but you would reserve your lien rights for the permanency so that you would still be paying the permanency at the 1/3 until the lien rights are extinguished. So it's really important for you to contact us and to discuss these issues, or to have your subrogation department contact us so that we can evaluate all of your options and make sure that you're making a fully informed decision when discussing your Section 40 lien rights.
Jen, I see that you have on there about Section 20.
Right.
Can you reserve your Section 40 lien rights under Section 20?
You can. It's something that if you do not reserve it, it's considered waived. Section 20 lien rights are generally, I would say, most of the time, are something that one of the reasons that you're Section 20 it, there's issues on the claim, and generally in your Section 20 offer, you're taking into account in the offer that you're waiving your Section 40 lien rights. So your Section 20 offer may be reduced based upon that potential recovery, whether it's known or unknown. So that's something that you want to do. If you want to reserve it, it's something you should put in the order. If it's not in the order or on the record, it's considered waived. The other thing to consider is just because you're waiving your Section 40 lien rights for the Section 20 you're not waiving those for the med and temp. That would specifically, again, have to be in the order that you were waiving. So opposite of the Section 20 portion, it would have to be in there that you were waiving your entire Section 40 lien rights. Otherwise, it's assumed that it's still reserved with regard to the med and temp. So keep that in mind.
We're going to talk about a couple cases now that have to deal with the Section 40 lien rights and whether or not it attaches to the entire recovery and what you can actually recover for. The first one we're going to cover is Midland's Insurance versus Terra. It's a 1986 case. This is a Supreme Court case. The petitioner was involved in a motor vehicle accident, brought suit against the other driver as well as its own insurance carrier under underinsured or uninsured motorist coverage that we all have as part of our insurance coverage. The court determined that Section 40 lien rights attach to all third-party recoveries, including the UM and UIM recovery. In this particular case, counsel tried to argue that you can only recover the Section 40 lien rights against the other tortfeasor and not against their own insurance company. That's a pretty straightforward case. The court basically says any third-party recovery is potentially lienable under Section 40.
So it goes back to the discussion that we had earlier when we were talking about, so the White's per quad claim isn't something, but a medical malpractice or a legal malpractice claim that stemmed from the injury are. This is similar in saying that the UIM claims are also part of that, and you can recover your. So a lot of times you have the recovery against the tortfeasor, and then you also have the UIM claim. They a lot of times don't settle together, so you may have two separate recoveries, one initially against the tortfeasor and then one later on. So it's important to keep those in mind and make sure that you understand your right to recover on both of those.
The next case that we're going to talk about has presented a lot of confusion with regards to what rights you're entitled to, when you can bring suit. The case is the Continental Insurance versus McClellan.
And in this case, you have the employee was injured in a motor vehicle accident, and they opted not to pursue a third-party claim against the other driver. So the carrier in that instance decided to pursue the claim. After the 1 year, they notified the employee like you're supposed to, and they decided to pursue the claim on their own. And they filed suit, and they tried to recover their Section 40 lien rights. Keeping in mind, when you file suit, you get 100% of whatever you recover. So in this instance, the case specifically indicates that the carrier steps into the shoes of the employee when, and whatever their rights are, that they have the same rights as the employee. And this case causes some confusion with regard to whether or not, in this instance, they were talking about specifically the verbal threshold. And the court in this case said that since the petitioner or employee elected to have the verbal threshold, that those limitations were also imposed on the workers' compensation carrier. But that case, I think it's not as clear as you would think. And so Rob's going to talk about some more recent case law to keep in mind, and one of our suggestions with regard to your litigation rights with regard to the third-party claim.
I'm going to do the next two cases together because they were actually decided right around the same time period. The first one is Lambor versus Travelers. It's a appellate division case in 2016, along with the Talmadge versus Burncat matter. These cases give the carrier a reasonable argument that previously the defined verbal threshold that was mentioned, as Jen said, in the McClellan case, does not bar the carrier from still bringing a Section 40 lien rights claim against the tortfeasor. In the McClellan case, it has been previously interpreted that since petitioner couldn't bring their claim because of the verbal threshold, the insurance carrier was prevented from doing that also. But we've had many discussions with regards to that, and the benefits that are being provided in the workers' compensation case are economic in nature. The verbal threshold applies to non-economic damages such as pain and suffering. As you know, there's no pain and suffering in workers' compensation. So because of that, we now determine you can bring this suit even if the verbal threshold applies. And you'll see later on there's a case that specifically that this is what the court was talking about actually in these cases. They presented that the verbal threshold, which limits the third-party plaintiff from recovery of non-economic damages, does not apply. The benefits provided under workers' compensation, including temporary disability, which is considered partial wage replacement, medical benefits, and permanency, are compensation for loss of future earnings, should be considered economic damages and therefore are not under the verbal threshold under the Act.
And that's really the key is whether or not it's in New Jersey. One of the few benefits that we get with regard to workers' compensation claims is that we don't pay for pain and suffering, unlike a third-party claim. So medical indemnity, all of the payments that we make are for economic damages. So it's important to know that these cases give you an argument to recover your Section 40 lien rights, even when the verbal threshold applies. So it's really important to keep that in mind and to understand that you have this right to recover.
Another case, this is the Dorfler matter. This was also decided in August of 2016. In this case, just prior to the settlement of third-party case, PMA asserted its Section 40 lien rights with regards to the medical expenses and temporary disability that was paid under the workers' compensation case. In that case, the petitioner's counsel tried to argue that while they're entitled to the reimbursement for the temporary disability, they're not entitled to reimbursement for the medical benefits. They tried to argue that those were not subject to the lien under the rules.
And that goes to the point of, like, most of the time you'll hear it said, is this something that's boardable? And in this instance, they were arguing that since the employee couldn't board these types of benefits, that the Section 40 lien rights shouldn't apply to them. And this case basically tells you that doesn't apply.
That's correct. The court said no. All benefits provided by the workers' compensation carrier are subject to the Section 40 lien rights. The reason why this was such an important decision is there had been previously a Superior Court case.
Devers.
Right. And that's, if anybody has heard the reference to the Devers, it's D-E-V-E-R. This was a case that was decided where the court had determined that if the medical benefits were not boardable, then they were not recoverable under Section 40. All of the petitioners' counsels and workers' compensation cases jumped on this the minute it was decided and sent out global letters to all their opposing counsels saying we're no longer going to consider your Section 40 lien rights because of the Devers matter. There's been now multiple decisions since that time period which have basically said Devers is just plain wrong.
Well, it clarified Devers and just made clear that you can recover those benefits. And it's really important for you to keep in mind that thinking about whether or not you have a third-party claim and evaluating it, it's important for you to consider. We also have a lot of times where you're not notified, so making sure, depending upon the claim, always asking counsel, especially when you get the claim, even if a workers' comp claim has not been filed, making sure that you reach out to the petitioner and let them know whether or not, or ask whether or not there's a third-party claim pending. They may not know, but you have an obligation to send that notice to them, especially if there's not a pending workers' comp claim, because they may have a liability claim pending, and they may just have elected not to pursue a workers' comp claim. So keep that in mind, making sure that your lien rights are protected. And one of the things that we see a lot is some of the courts, especially for workers' comp, some of the judges try and guide the petitioner's attorneys in how to handle these third-party claims to maximize their benefits. And so we've had certain judges that recommend those types of compromises that we talked about before, and the ways in which you should, whether or not you keep in mind, the judge recommends to them trying to take the third after costs have been deducted, whereas we're going to recommend to you the opposite. The judge wants to make sure that they understand that that's standard practice, that unless you say it's after costs, it's always considered to be before costs, those types of things. And it's something to just keep in mind, those issues and how you want to handle it while trying to save on your potential litigation costs, because a lot of times they may threaten that they're not going to move forward with the claim, and evaluating whether or not you should even consider moving forward with the claim.
So if Section 48 is an issue in your case, what should we do?
In regards to the Section 40 lien rights, what we recommend at this time is that you should consider pursuing your own third-party claim. It's something that, just because with regard to those earlier cases we talked about, the verbal threshold doesn't apply to the carrier based upon these more recent cases. Even if they're going to try and make the argument that under McClellan it does, there's been subsequent case law that makes clear that the verbal threshold, because of the fact of the economic damages, doesn't apply to workman's comp. So if you have that situation, what you want to do is contact us, and we can help you work out the recovery with regard to the Section 40 lien rights. And I'm going to introduce you right now to one of our partners, Larry Bennett. And Larry handles the subrogation for our office. He is located in the Mount Laurel office along with Rob and myself. And Larry and I regularly handle subrogation claims.
Good afternoon. I just wanted to jump in. When Rob and Jen told me they were doing this seminar, I just was very excited just because of the Talmadge and Lambor cases that Jen and Rob talked about. I've been doing general liability, subrogation, and auto defense for almost 30 years, and it was pretty much the opinion of the bar in New Jersey that McClellan did bar a workers' compensation carrier from getting their lien money back when the verbal threshold applied. However, in light of Lambert and Talmadge, that's no longer the case. McClellan has been clarified, and the carrier now has a very strong argument, and courts are following it, that they can get their money back and their lien money back in verbal threshold cases. So, as Jen stated, if you have these cases, we suggest that you pursue them, contact us, and oftentimes we can get it resolved prior to suit with just simply a letter.
And it's something that what you want to do is, obviously you have that 1 year where they have the right. A lot of times we may be told in advance that they're not pursuing it because of the verbal threshold. Because you recover 100% if you take on the litigation costs, that's good news. It's something that you would want to consider. There is some question about whether or not the verbal threshold would apply to even the employee or the plaintiff in their third-party claim, and that's not yet specifically clear, but it's definitely clear that the carrier would be able to recover even with the verbal threshold. So we strongly recommend that after the year, if litigation hasn't ensued, you contact us and we can take the necessary steps to try and get the recovery.
Absolutely. I think the bar is pretty much confident now in one of these two cases that you would be successful on a verbal threshold case and recovery.
Mm-hmm. And so at this point, with regard to Section 40 lien rights, we really just recommend that you take a look at the claims when they're coming in about whether or not there is a viable third-party claim. If there is, make sure that you notify your attorney so that we can obviously reserve your Section 40 lien rights. If it is pre-litigation, it's something that you can handle and just notifying the employee by letter of your Section 40 lien rights, because at this point you don't know whether or not a claim may exist, or if they haven't filed a workers' comp claim, it doesn't mean that they're not filing a third-party claim or that there's a potential recovery there. So again, even if they don't file their own third-party claim, or even if they don't file a workers' comp claim, you still may be able to get back your recovery. There's also, just keep in mind, with regard to Section 40 lien rights, even if you've paid out a claim because you're investigating and you've reserved your rights for med and temping, you've paid some money on the claim, but you ultimately deny the claim, that doesn't waive your Section 40 lien rights. You still can recover those Section 40 lien rights for any money you paid in those ultimately denied claims. There is a case on that point. So just when evaluating these, just contact us and we can go through what you need to do with regard to the claims. With regard to our future workers' comp cases and with regard to these future webinars, if you have any questions about our webinar series, you can contact Isa Lindsay. Her email address and phone number is on our website, and it's on the webinar, obviously. And our future upcoming programs are on the website. We have one coming up on September 19th with regard to the workers' comp in New Jersey. We have one on October 17th, and we have some in November and December. So take a look at the website. Hopefully you've enjoyed learning about Section 40 lien rights. And if you have any questions with regard to the workers' comp, feel free to contact Rob or I. If you have any questions about subrogation, feel free to contact Larry. And if you have any future claims that you need assistance with, just let us know.